Hello. Here's a little fact pattern that can make it very difficult for someone to get an attorney to represent them. So here's an example. A person just recently drops from part-time but over SGA. And if you don't know what SGA is, look at the video. You might find under the glossary playlist. There's a few of them. Um, So the person drops down to under SGA, say July 2023. That means that is the first month she can allege disability that would meet potentially the definitions by Social Security Administration, because as you might know, we can't be earning more than SGA and have an application fully taken and progress onto a medical workup to determine medical disability, because we cannot be working SGA. That is contrary to a finding that you're eligible for SSD. Okay. So add another dilemma. The person has an overpayment of $12,000 to the SSA. How does that happen, you ask? Okay, no, she was not on Social Security Disability or SSI before. She's always been working. But there can be other ways that one is eligible, for a Social Security benefit, and that would be as a dependent under someone else's work record, perhaps a spouse who passed away and the living spouse is caring for children under 16. Let's say the SSA is paying the caretaker amount, but then the caretaker goes to work, not realizing that even part-time work of a certain amount will then make her not a dependent on the deceased spouse's caretaker dependent benefit. And now all the amount paid while the person was working too much, even if it was still part-time, if it was too much, it's like an earnings test. Those months of Social Security would be an overpayment to be paid back. So that's an example of how you can have a $12,000 overpayment, and you were never even a disabled person at that time, but you were receiving benefits for a different reason, like caretaking for minors. Okay, so the dilemma to the attorney and the claimant trying to get an attorney is that if the attorney files right away, say in August, for the claimant, alleging a July onset date, because that's when the person no longer could really work the amount the person was working and the income fell to below SGA. Okay. Let's say, perfect scenario, that person does prevail, say a year from now, and the SSA agrees that indeed she was disabled in July of 2023. That means there's the 5-month waiting period, August, September, October, November, December, unpaid, despite being disabled back in July, because there's that 5-month waiting period. Most insurances have some sort of waiting period, so that's not unusual. We hate it, but I understand it. So her first back benefit check would be, or forward benefit check, depending on when, if she won before then or after then, would be January of 2024. So if she hasn't already paid off that $12,000 overpayment, she owes the SSA, then presumably the SSA is going to withhold her Social Security disability for X amounts until it's paid off. So if she were getting $1,000 a month from Social Security disability, it would take 12 months of constructively receiving her Social Security disability, starting in January of 2024, the entire year. They're going to constructively pay it. She'll get a 1099 for it, but then it's actually being paid right to her debt. That all being said, there is no contingent fee that can be derived from accumulated back benefits, right? There just isn't. So it would be difficult for an attorney, unless they have no pro bono cases right now and they're just, the world is their oyster and they have all the time in the world. And a lot of us, make sure we have a roster of pro bono things that we volunteer for. But if that's supposed to be, a paying case where you work for the win and that's how you get paid on that contingent win as approved by the SSA, that's already like a known. Even if you win and bust your butt, you're not going to get paid. So some of the alternatives the person can consider is, and again, this is going to depend on wherewithal. It's easier for people who are, say, married and have a working spouse, so they're not relying on their own little part-time income while they're disabled and trying to file. But one can put money, they can, if they have it, they can put the fee that will never be derived from back benefits, but might later be approved on fee petition after a win, put a set amount of trust monies into the attorney's trust account. That could be anywhere from, I mean, I don't think an attorney is going to ask for more than $7,200, which is the fee cap. Then if you prevail, whatever the SSA approves as a fee for the work done, because it would have to be by fee petition, because there's presumably no back benefits. If the SSA approved $7,200, then the whole $7,200 would be used to pay the fee. It's been sitting in trust, nice and safe. If the case is lost, $7,200 goes back to the claimant, because it's a contingent, most of us would still argue or agree that it would only be contingently paid if they win for you. If the approval by the SSA is, say, $5,000, then only $5,000 would come out of trust and be paid to cover the legal fee, and then $2,200 would go back to the claimant, like refunded back out of the trust account. So that's one option. But a lot of people don't have, say, $7,200 to put in a trust, or $5,000, or whatever the attorney is going to want as a safety for himself or herself to eventually be paid after they put all the work in, and to pay their employees or their contractors who help them. So sometimes it could be where, okay, there's not 5,000 or 7,000 or whatever you're going to trust, but they could come up with 1,000. 1,000 goes into trust, and then they go on they just put in X amount every month. So it starts to accumulate so that it will cover a bill later. Either that, or it all gets sent back to them if it's a loss. That's probably the easier route, and I think most people do that one. But there's also the other way. So those are the options. And the third option that the only one I could see, because that's, again, assuming that the attorney or the non-attorney rep is not going to agree to take a pro bono in a situation like this, because they're usually taking pro bonos everywhere else, particularly for the homeless folks we have, who there's not going to really be a fee generated for a winning case, oftentimes. So, or if they're doing an overpayment where there's no fee, or, whatever the case may be, consultating, whatever. The other option is to go pro se if you can't get a lawyer and you can't do that retainer trust business that I just mentioned. So one can, of course, always file pro se. It would be troublesome if they take a pro se all the way to hearing and lose at hearing, because now they have a judge's decision of denial, which can be very, it can make it more difficult to win on the next application because of that judge's denial on the existing evidence. So unless the evidence somehow gets crazy different afterwards, it sometimes makes it difficult for the SSA or a future judge to say, yeah, I'm going to decide that she was disabled right after that judge's denial, even though nothing new has happened. So it's almost like I don't want to say it's like a courtesy respect for the judge's opinion. But if the judge found that it was not disabling, even though it was impairments and they were probably severe, sometimes it's difficult to get the next body who's looking at it on a new application to decide that it is, unless, of course, there's new and better evidence. And so that's always the goal. I would add that in this particular kind of scenario, if the person did start to do the in-trust and start putting money in a payment plan, not filing for, the attorney might say, I'll take it, but I'm not filing for you now. You either do it yourself and I'll handle you later if you need it. But it could be just delaying the application until all that funny business is over. And that's really just kind of a personal choice, what you can manage. So it could be where a person, instead of filing in July of 2023, when they jump down below SGA, instead they use the next year to follow astute, freely given legal advice on areas to pursue in terms of medical evidence that's going to be needed when they do file. And then file a year later. They're not going to lose any benefits if they prove it, because you can always get paid back up to a year prior to your date of application. So if you filed in July of 2024, they can still pay you back to July of 2023 when you say you became disabled. Of course, they're still going to have the 5-month waiting period as always, but that's an option too, just delaying. So know those options, because there can often be a workaround like that, so you can get the attorney of your choice, and that attorney doesn't have to do yet another pro bono, which obviously everyone's got their limitations if they want to keep the lights on, keep the business going. Okay, so just an interesting scenario I wanted to share, because it happens maybe not that same exact scenario, but scenarios like that where you find that the attorneys just can't take the case, because it's like saying, can you come, volunteer for me for 3 years? Like there's only so many people they can do that for at one particular time. And everybody's got unintentional ones and known intentional ones. And there's a cap to all that. So alrighty, I hope that just gives you an example of what problems one might walk into when they're trying to secure an attorney and they have some of this baggage attached to their case. All right. Take care now. Bye.